David Tate contacted me this week about an issue with a used car that he purchased. The issue is that when he bought the car from the dealership, it described it as having one previous owner. And that information was correct, but David has now discovered that that one previous owner leased the car to a car hire company, therefore meaning that that car has been hired out to all and sundry. David now asks me, should they have told me that? Or was the description of one previous owner all they had to tell me? Well, the answer to the question is they should have told him. And the reason for that is that when you sell goods to consumers, you must give the consumer all relevant information that the consumer needs to make their purchasing decision. And importantly, if there's a piece of information that you leave out, so here, if there's a piece of information the dealership leaves out, and that information would lead to the reasonable consumer concluding that they do not want to proceed with the purchase, that becomes a problem. That becomes what we lawyers call a breach of contract. Now here, most people would not buy a car, or most people would be advised not to buy a car if that car had previously been hired out. There's two reasons for that. Firstly, wear and tear. If lots of different people have driven the car, it probably means it's not been looked after as much as it would have been had only one person driven it. And secondly, sometimes a car which has been hired out can cost you more with insurance, or sometimes insurance providers simply say, we're not insuring you. There is actually a third reason. When you come to resell that vehicle, the resale value will obviously be severely affected if you declare, as you should do, that the car was previously subject to hire agreements, again with all and sundry. So for these reasons, the garage here has done wrong. There's a breach of contract. And in my view, this means there's one of two remedies that can be invoked under the Consumer Rights Act. The first one is to say, here's the keys back, I'll have my money please. You've effectively missold me the car. You've not told me what you should have told me. It's a breach of contract. The alternative remedy, the one that would be probably more common in this situation, is to say that car, which was previously hired out, now is not worth the money it was worth when I purchased it because of the hiring scenario. Therefore, I'll have a price reduction. And that would basically mean they give you some money back, so that effectively you bought the car for less money for a price that reflected that this car had previously been hired out. There's one more twist to this, because selling a vehicle that has previously been hired out and failing to tell your customer as a car dealership is potentially a criminal offence as well. This could be reported to trading standards. That would be the local trading standards to the garage, who could investigate, who could take criminal proceedings. So that would be something to threaten the garage as well, if, in David's case, they failed to provide him with a remedy that he is now entitled to.